Hi, I'm Linda Amato with the firm of Amato Law. We are solely devoted to the practice of estate planning and located here in New York City. And I'm bringing you this educational video today to talk about the overlap between estate planning and matrimonial law. Once your divorce is final, there are certain fiduciary duties that are automatically revoked by operation of law in New York. And that is, your ex-spouse can no longer act as your fiduciary under your will. They can't be your executor. They can't be a trustee of a trust. They can't be your power of attorney agent, and they can't be your healthcare proxy. Okay? However, the will is not revoked. It's still a valid document. The only thing that's not enforceable would be whatever you're gifting to that ex-spouse. That would not be enforceable. However, what's important to keep in mind in New York, every state has a different rule on this, but in New York, let's say Mary and Bill, they got a divorce and they never updated their will, and Bill dies 5 years later. And in the will, it said Mary gets everything. And then if she's not alive, it goes to her father, or it goes to her son, who's a child from another marriage. Well, when Bill dies, Mary's not going to get anything because of the divorce. She's just not entitled to it. But where did it lapse to? Where did the gift lapse to if Mary wasn't alive? It was going to her father, or maybe it was going to a child from another marriage. That's enforceable in New York. And that's an outcome that I think people aren't really aware of. They're just assuming, oh, well, my spouse is not going to get what I said in my will. I don't need to update it. But you got to think a little bit further down the road as to what the document is calling for upon death, because under law, it's treated as if the spouse had predeceased, as if the spouse had died. So that's very, very important to keep in mind. It can really produce an outcome that is not really the intent.